16th, 2025 at approximately 10:25 p.m. The officer was traveling on East Sam Houston Tollway and observed the vehicle traveling at a high rate of speed, overtaking other motorists and changing lanes without signaling. The officer observed the vehicle get on Ship Channel Toll Bridge and pace the vehicle at 75 miles per hour in a 50 mile per hour zone. The vehicle further failed to drive in a single lane and a traffic stop was initiated. The officer made contact with the defendant, the driver of the vehicle, and observed the defendant to have slurred speech and odor of an alcoholic beverage. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 2 out of 4. The defendant was read the DIC and refused to provide a specimen, and a blood search warrant was signed and executed.
Ma'am, I'm going to find that there's enough probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming anything of this nature, I'm going to revoke your bond, put you in jail. Do you understand, ma'am?
There's no driver's license on file for the defendant.
Okay. Any priority to WIs?
No priors, Your Honor.
Okay. If you do not have a Texas driver license and liability insurance, you are not allowed to drive. Do you understand? You will be signing an affidavit with me today promising me you're not going to drive. I take it extremely serious. You just saw what happened. If you don't have a license and insurance, do.
This is textbook DUI probable cause. Speeding, lane violations, slurred speech, odor of alcohol, and failing standardized field sobriety tests. 6 out of 6 on HGN alone is usually enough to greenlight the case, and when the defendant refuses a blood draw, that doesn't help them. The judge isn't deciding guilt here, just whether the state has enough to move forward. And spoiler alert, they do.
We'll have you sign a receipt with Victoria. We will have you get with Felicia at some point for your bond conditions. In the meantime, we'll have you fill out an application, then I'll have you speak to a lawyer here momentarily. All right? Please. And then if you could give her an application. Mr. Leary, you're charged with racing on a highway and you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, at approximately 12:51 a.m., the officer on-viewed 2 vehicles at the block of Tomball Parkway, blocking the moving lane of traffic. The officer observed a white Jeep and an orange Corvette line up directly next to each other side by side, and the vehicles accelerated at the same time at a high rate of speed. The traffic stop was initiated of the white Jeep, and the officer made contact with the defendant, the driver, who gave his name and was identified by his Texas driver's license. The other officer stopped the Corvette and detained the second defendant. The driver was positively ID'd by the Texas driver's license.
Listen carefully to the judge's tone here. This isn't casual advice, it's a warning shot. Bond conditions are not suggestions. Random testing, zero tolerance, and immediate jail time if violated. Judges use this moment to draw a bright red line, because once you cross it, there's no second chance conversation, just handcuffs.
Privilege to drive away from you permanently. Do you understand while this case is over?
Yes, sir.
Open. The ability to not drive in Houston blows. Trust me. Do you understand?
Yes, sir.
Now, you have a lawyer. It's your responsibility to stay in touch with Mr. Clay, and he'll tell you when you have to come back to court. I'm going to waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him, and he'll tell you when you have to come back to court.
Yes,
you
sir.
pick up a new case, you endanger my public. I only have one place for you. You understand?
Yes, sir.
All right. So I'm going to have you sign a receipt with Victoria. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and after that, you'll be free to go.
Have the excuse.
Yes, sir. Thanks. It's come to my attention that you've picked up a couple new cases while you're on bond.
Yes.
So state's asking me, or I guess, what are you asking for, state?
We were asking for 5,000 on each of the cases.
To revoke the bonds?
Yes, sir.
On which cases?
On one moment,
Mischief.
the criminal mischief and the assault bodily injury.
And that is because he has picked up a new criminal trespass.
Yes, sir.
Did you say that there was one that you were going to have indicted too?
Yes, sir. And we're pending on the offense report for that still at this time. So we're waiting for a new date.
What is that?
What is that case?
Yeah, what is that? Is it another trespass? Is it a theft?
Assault bodily injury.
Well, there's another assault.
Yes, sir.
Yes, sir.
Did you know about this?
Yes, because that one was no PC by the magistrate when all of these cases came to the court. But it was no PC because they, I think fat fingered the date of the offense as 2021, not 2024. And so it was outside the statute of limitations when it went before the
Someone
magistrate.
accidentally put 2021 on the actual report instead of
And
24.
my understanding is that the state is having to get a copy of the offense report, and then they can take it to the grand jury with the correct date.
Okay. So what is your response as far as the mischief and the assault on the bond revocation?
We're in agreement with the 5,000.
Okay.
He has a case upstairs, so.
Oh, I see. Right. You have a felony case. So, all right. So on the mischief and then the assault, if we can put it at now 1, 2.
Judge Jackson had previously revoked the ABI when they were last week.
Yeah. But I think they're all in agreement. So we'll do 5,000 in 2, 4.
5,000.
Yeah. On the assault and the mischief. Right. We'll leave the trespass as is. Right. So Mr. Rodriguez, what's happening now is I'm going to revoke the bond on your 2 older cases due to the fact that you continue to pick up other new cases. You can't expect.
Right. Yes.
Right. So,
Just for clarification, the case that's being taken to the grand jury, that's already kind of accounted for in the 5,000. There's not going to be a new BVR when that.
right.
Okay, I just.
Notice how the judge doesn't even need a speed number to find probable cause. Racing is about behavior, not just miles per hour. 2 cars lining up, accelerating together, that's enough. And when the judge starts talking about permanently taking your driving privileges, that's not courtroom drama. That's a judge signaling they're done playing games.
Judge, I don't know that it really matters because 1,000 or 11 billion, 1,000, it's.
Yeah, I guess we'll cross that bridge when we get there, whenever they do get it done. Yeah. Okay. All right. So if you do bond out, I'm going to put a GPS monitor. I don't know if you're going to get out or not, but I'm ordering you not to have any contact with the complaining witnesses in these cases, not to be in possession of weapons, and I'm going to put a monitor on you so I know that you're not going over there. The monitor will go on you prior to your release from custody if you are able to make bond.
Yes, Your Honor.
Do you understand? Do you have any questions?
No, Your Honor.
Okay, man. Good luck, Mr. Rodriguez.
Thank you.
So we need him to sign before he goes, please.
Thank you.
Thanks, guys.
I'd be excused.
Yes.
Just come over here, Mr. Rodriguez. Have you signed for the bond?
So I will, Kelsey, I'm going to grant the motion that you did in the queue, the motions that you filed, I'll grant them.
Thank you, sir.
Okay. Are you ready? Okay. Yes, ma'am. I already done it. So what I'm going to do is just unset term. Yeah, he's a big boy. He knows. We're done. Doesn't want the help. We'll just unset term and then he's just free to go. So just, nope, just admonish him if he picks up another case. Thank you. Yes, ma'am. Mr. Butler.
Yes.
I'm ready.
The Hassan that's on the docket.
You've been so patient.
What's that?
You've been so patient.
I get, well, I had some rounds to make this morning.
Hassan.
Yes, Hassan. So she's here from California. So what happens is she's on PTI. We get notification that there was some sort of violation. We hadn't pulled any of the stuff to really take a look at it. She's given me.
You've not seen what the violations are?
I'm sorry?
You've not seen the violations?
No. I've seen like the kind of the blanket thing where they allege the usual, like a blow, something like that, or a misty blow.
Ms. Hassan, come up.
And so what we're going to request is obviously a recess to be able to speak to the appropriate person. Ms. Geis, I believe, is in charge. Right.
Has she already been booted out?
No, this is the initial, they always,
If everything didn't happen on the PTR program, she would have been removed. But because I guess everybody is in limbo, they're just waiting.
What violations do we have?
218 is a lot. She's averaging 14 to 34 skip tests a month on her device. She tested positive for THC. She failed to report for her office visits. on the September 24th, October 8th, December 3rd, December 31st, and January 8th.
Can I,
No,
So obviously,
actions speak.
yeah,
Right.
but Your
Stop,
Honor.
stop.
This is where things unravel fast. Picking up new cases while on bond is the fastest way to lose freedom without ever seeing a jury. Bond is trust. Stack new charges on top of it, and the court stops asking questions and starts revoking bonds. GPS monitors, higher amounts, no contact orders. This is the system tightening the leash in real time.
Supposed to be done. I'm putting a scram monitor on you. That's it.
I do have an
Guys, you talk over there. You're on bond in this court.
Okay, and I will travel as well with the monitor, but I did have an issue last time I came with the DUI machine. It stopped working because I traveled out of state and I was ordered to pay a whole new device, turn it in, and I had to wait a whole week without testing because of that problem. So I just don't want to run into that same problem with the ankle monitor.
So when you have issues,
Mhm.
you're supposed to contact the provider immediately and let them know, hey, I've got an issue. You go to where they are, right? And there are devices that you can, they're global. You can go all over the globe. They use, Wi-Fi or whatnot, so that it doesn't matter where you are. You can be in Abu Dhabi. You're still able to use the device, and the device can go internationally. There's just, if you know that that's a lifestyle you have, that's the kind of machine that you get. So regardless, I'll give you, the case is 400 days. I will give you some time, right? Tell me, how much time do you want?
I don't know, like 3 or so weeks, or
Done.
because everything else in the way that, and then can we wait for appearance the next setting?
Well, I don't know yet, because if they deny it, then we need to figure out what we're gonna do.
Figure something out. Yeah.
So,
Like she and I haven't really had the time to sit down and just really go through, like obviously she's very passionate about what happened and.
so amending your bond conditions, you will get a scram ankle monitor now. If I find that you're consuming alcohol, and I don't care what it is, I don't care if it's mouthwash, I don't care if it's a tequila lollipop, I'm gonna revoke your bond. Do you understand?
Yeah.
Can you run her license to see if she has a license?
Yes, Judge, I'll run it right now.
Today,
At what time?
later in the evening, like around 6, 7.
So Judge, her flight leaves today at 6 p.m.
She's gonna go now. We'll get her in now.
Get it done.
Right now.
Okay, right.
Your Honor, it appears to be a valid California license.
As long as you have a valid license and liability insurance, then you can drive unless, well, no, you're not allowed to drive without an interlock. So you have to have the interlock.
I'm not driving right now.
I'm just telling you what
Okay.
the expectation is, so that, I don't want to have to revoke your bond. You have to know what the expectations are. Now, okay, so we'll give you whatever time you want at the next setting. Because your case is old and because of their violations, I'm not waiving your appearance anymore. If you get her back in to the program, I guess at that point, we don't leave her here, right? I'll waive it. But if it's denied, then she's got to come back here so we can resolve it one way or the other.
Okay, I'll just file a new court.
Just let me know. Yeah. Okay. All right, man. Good luck. It's fair. You are charged with assault, bodily injury. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, man.
Yes, Judge. On January 3rd, 2025, the officer was dispatched to a disturbance at a residence in Harris County, Texas. Upon arrival, the officer met with the complainant, who knew the defendant as his sister-in-law. The complainant stated the defendant came to his residence shortly after a verbal dispute with his child's mother, and the defendant arrived and told the defendant told the complainant to come outside and meet with her boyfriend. When the complainant stepped outside, he was assaulted by the defendant by a closed fist to the back of the head. The complainant stated the defendant continued to strike him in the back of the head before he began stumbling down the stairs. The complainant was then assaulted by an unidentified black male while still being assaulted by the defendant and the defendant's sister. The defendant was gone on arrival, but was contacted via a public service by the officer and was ordered to return to the location.
Did the other person get arrested as well?
It appears there is a connected case, Your Honor.
The sister was also arrested.
So we have 3 co-defendants or
No,
2
just
co-defendants?
Yeah, just the sister, Your Honor.
You know of alcohol or any kind of,
There's no allegations, Your Honor.
see that she's on probation as well. Ms. Fair, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm also ordering you not to be in possession of weapons, not to have contact with the complaining witness in this case, and not to be in contact with any of the co-defendants. Do you understand? Yes? Okay. If I find that you violate these conditions, I'm going to revoke your bond. I'm going to put you in jail. I'm going to protect my community at all costs. You understand, ma'am? You need a lawyer, ma'am. Okay. Ms. Fair, I need you to fill out an application for me. I'll provide you a lawyer after that. Don't violate these conditions. Do you understand, ma'am? Okay. Please, we'll have you sign a reset. You'll get with Felicia for your bond conditions, and then we'll have you fill out an application.
I spoke with the complainant and
Ma'am, hold on. Come back up.
he's no longer living, he still has the lease to the residents of the 1180 Grant Road, but he's not living there anymore because the co-defendant lives there. He's actually living at his sister's residence, so if we could get a restriction, like a
Sure, just provide it to Felicia so she knows, and then we'll put that in the order as well that she's not to go to this location.
yeah, judge.
Okay. Okay, ma'am. Please. Mr. Johnson, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 17, 2025, the officer was dispatched to the theft of a motor vehicle at a residence in Harris County, Texas. The officer made contact with the complainant, who advised that his truck was stolen off the property at 12:42 p.m., and the complainant showed officers clear footage of the theft, where the officer observed 3 white males exiting a motor vehicle, one suspect going under the hood of the complainant's vehicle and getting in the passenger seat, and another suspect drive the motor vehicle off the property. The officer got the suspect's motor vehicle's license plates, ran that license plate through Lens, and got an address. When the officer arrived at that address, he observed the motor vehicle used to commit the theft in the driveway and knocked on the door and met with all parties inside the home. All subjects matched the subjects on surveillance, and the defendant had the same clothes as in the footage. The second defendant admitted to driving the motor vehicle and showed where he dumped the vehicle, and the complainant's vehicle was recovered. The first defendant, Mr. Johnson, admitted to helping the second defendant steal the motor vehicle.
So you're telling me that they allegedly stole a car.
Yes, Judge.
He's charged with a misdemeanor theft, Class B.
Yes, Judge.
What is the value of the car?
According to the DIMS, the complainant advised the value was $600.
Does he make a statement that he knows the car stolen?
He makes a statement that he admitted to help steal the vehicle.
Okay. All right, Mr. Johnson, I'm going to find that there's probable cause to go forward with your case. We do have co-defendants in this case, do we not?
Yes, Judge.
I'm ordering you as a condition of your bond not to have any contact with the co-defendants in this case and not to have any contact with the complaining witness in this case. You pick up a new case, you endanger my community, I'm going to revoke your bond, I'm going to put you in jail, and I'm going to make it extremely high. Do you understand, Mr. Johnson?
I do understand.
What do you do for a living, sir? How do you support yourself?
Sir,
How do you support yourself?
I'm trying to get disability right now, sir.
All right, I'll have you fill out an application. Do you mind giving me an application? Do not leave until you sign our bond conditions, otherwise
Yes,
I will
sir.
issue a warrant for your arrest. I'm going to give you an application. I'm going to have you sign a receipt with Victoria, and then we'll have you take a seat in the jury box, sir.
And
Mr. Shagoya, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You're also charged with unlawful carrying of a weapon. On the gun case, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 18th, 2025, at approximately 4:30 a.m., the officer observed the vehicle fail to stop at a red light at the East Texas Freeway on Harris County, Texas. The vehicle would have struck the officer's patrol vehicle had the officer not come to a stop. A traffic stop was then initiated, and the vehicle continued to drive 0.5 miles before stopping. The officer made contact with the defendant, the driver and sole occupant, and observed an odor of alcoholic beverage, glossy eyes, and slurred speech. Standard field sobriety tests were conducted, HGN 6 out of 6. The officer did not conduct walk and turn and one leg stand due to safety concerns and the nearby sidewalk not being level. The officer observed a Glock 9mm in plain view from the front passenger window located on the passenger floorboard near the center console, and a PC search was then conducted. A second loaded firearm was found in the center console, and the defendant was then read to DIC and refused. A blood search warrant was signed and executed.
Mr. Shigoy, I'm going to find that there's probable cause to go forward with the case. Have you run his license?
It is eligible, Your Honor.
I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're consuming, I'm going to revoke your bond, put you in jail. No more PR bonds. Do you understand? I'm also ordering you not to be in possession of any weapons as well, sir. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with him. If he tells me he can't get a hold of you or you've taken off and you pick up a new case, I will revoke your bond. Have you looked to see if he has any prior DWIs, Alex? Please.
He has one moment, Your Honor. No priors.
Okay. All right. So for now, I'll have you sign a reset with Victoria. We'll get you with Felicia for your bond conditions. And after that, you'll be free to go, sir.
Thank you, Judge.
Thanks, guys.
Excuse me.
Please. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 17, 2025, the officer was dispatched to an assault. Upon arrival, the officer met with the complainant, who stated she and the defendant have been in a dating relationship for 11 months. The complainant then stated the defendant had been continuously assaulting her, and she showed surveillance video of the incident to the officers. The officers observed the defendant grab the complainant by the hair and strike her several times in the face with a boxing glove. The officer also observed the defendant get on top of the complainant and pin her down, striking her in the face, and the complainant advised she felt pain from all the strikes. The officer observed the complainant to have visible abrasions on her left shoulder and bicep, along with redness on her face.
He just had an assault that was dismissed in October of this past year.
Yes,
Is this the same complaining
Same
witness?
complainant, Your Honor.
Okay. Mr. Marquez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with this person whatsoever. I'm issuing what's called a magistrate's order for emergency protection, which is a court order that identifies Ms. Rubio as a protected individual. You're not to commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code. Is this a stalking statute? You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the Melbourne Street place. Do you understand?
Yes, sir.
I want you to understand that I'm going to protect every single person in this county by all means necessary. You endanger my public, it's not going to go well for you. Felicia, I want to make sure that he's not consuming alcohol or drugs. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail, make your bond very high. Do you understand?
Yep, Judge, the milk was signed last Friday. It was signed by a magistrate court. On the 18th, or last Saturday, actually. You scroll all the way to the bottom.
Okay. So it looks like a protective order has been issued. I would get to know it because if you violate this protective order, the state can and will file a violation protective order. That is the capital murder of misdemeanors. Do you understand, sir?
Judge, the magistrate also did order a GPS device that was,
Yep.
installed prior.
I'm okay with that.
I have it on, sir.
Did you want do you need a lawyer, sir? Okay, so you don't want a court-appointed lawyer then? Okay, I'm gonna have you sign a reset. After that, we'll get with Felicia for your bond condition. After that, you're free to go. Don't violate these conditions, Mr. Marquez. It's not gonna go well for you. Do you understand? Okay, come on. Sir, you were charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 13th, 2024, the officer observed the defendant's vehicle traveling at a high rate of speed without a front license plate. A traffic stop was initiated, and the officer made contact with the defendant, the driver of the vehicle. The officer observed the firearm in the passenger side door, and the officer asked the defendant to step out. The officer observed a firearm in the driver's side door, and both firearms were unholstered. The officer asked the defendant for consent to search the vehicle, and the defendant agreed. The officer searched the vehicle within hand's reach of the defendant, and the officer observed a Ziploc bag in the glove compartment with a $20 bill and what appeared to be small baggies with a white powdery substance inside, believed to be cocaine based on training experience. The weight was 3.77 grams.
Okay, sir, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to be in possession of any weapons. Do not pick up any new cases. Otherwise, I'm going to put you in jail. I don't know what your immigration status is, but if you go to jail and you spend any kind of time there, immigration, and you're not here with proper documentation, immigration will put a detainer on you. You will be stuck like Chuck in there until this case is over with and then shipped off to immigration. So beware what you do. I don't know what your status is, but if you're not here with permission, be good. You have a lawyer because you have one that will waive your appearance, but it is your responsibility to stay in touch with him. You pick up a new case, you endanger my community. It's not going to go well for you. Do you understand? I will have you sign in recess, Victoria. We will have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then after that, you'll be free to go. Thank you.
Thank you, Your Honor.
Thank you.
You were charged with tampering with the government record with intent to make it genuine. Is that right?
I'm sorry. Say it one more time, Judge. I missed what you said.
You're charged with tampering with the government record. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 16th, 2025, the officer observed the defendant's vehicle with a paper license plate on North Freeway, East Service Road. The officer ran the license plate, and the license plate came back with no record. The officer observed the license plate was a copy and did not have required security features. A traffic stop was initiated, and the officer made contact with the defendant, the driver of the vehicle. The defendant stated he received the license plate from the person who sold him the truck, that he receives a new license plate whenever he makes payments, and that he thought that was legal. The defendant stated he did not have insurance on the vehicle, and the officer ran the VIN and discovered the motor vehicle to be salvaged. The officer also found the vehicle has never been registered and had never had a state inspection. The defendant provided a dealer tag receipt for the license plate, listing him as a purchaser.
So he tried to purchase in good faith, Judge. He just, I don't see how there's any criminal intent.
But he's making payments and he gets a new license plate every time he gets a payment.
That's what the officer says he was saying.
Well, that, right, but I mean.
Right.
Marcos, I see what you're saying because he's charged with tampering, right? To tamper, you must. I know, let's pull the code.
Right.
Because I mean, do you have to make a willing?
Negligently or recklessly.
An alteration, so to speak, you know? Let's see. $37.10. Bless you. No, that's. Oh.
Knowingly makes a false entry in the false alteration of a government record.
A person commits, if he knowingly makes a false entry in or false alteration of a government record, makes, presents, or uses any record, document, or thing with knowledge of its falsity with intent that it be taken as a genuine government record.
Your Honor,
I think that is what they're probably relying on in this case.
if I may, as the information alleges, it's subsection 6 where it possesses a governmental record with knowledge that it was obtained unlawfully. So,
Well, he doesn't know it was obtained unlawfully, even from.
Well, hold on. That's your burden,
yes,
right?
Judge, and in this case, we would show that reasonable certainty by his obtaining it every time he makes a new purchase and obtaining it from the person who obtained the vehicle rather than from the government. So it would be through that.
When I go buy a new car, though, they give me a tag. You know what I mean? So at some point, yes, you're supposed to get something like a license plate from, I guess, a state, from the state authority, right? They give you the license plate, but here,
They give you the paper plate, and you assume that they're going to do all the paperwork behind the scenes. They send it to the government, to the state agency. Then the state agency sends you the metal plates.
if this had been like maybe a month or two that he'd purchased it, perhaps. But if we're talking that he's had this car for like a year, then I don't think that's reasonable. I don't think that's a reasonable argument to make. So,
And I don't know how long
and
he's.
this car purchase,
Let me see, Your Honor. So the only thing in regard to the status of the vehicle is the officer only found that it was a salvaged vehicle, and he lists a date of loss as May 29th, 2020. So I don't know if that's when the defendant obtained it or that's just.
no,
whenever
that's just when it was salvaged at
Yeah,
that
so
time.
that's
So
the
at that
only-
point, you can't even drive the car because it's salvaged, right?
Right, and
It's a
that's
salvage title,
the
but
date that the officer provides. So, and, so with the information we
you have a
have,
copy of the tag?
let me see. So the buyer's tag lists an expiration date of February 5th, 2025 and lists the vehicle as a 2007 Chevrolet and it doesn't
Is
list.
this, it should say like a date of purchase, right? Why don't we do this? Look,
So it says it expired February 5th, and this happened on January 16th. And I just asked him when he bought it. He said it was about a month and a half ago. And I said, how many?
let's do this. Show me. Let me give you more time. Let me just do a little bit more diligence.
Okay.
All right. We'll come back, but let me burn through all this because I didn't think it was going to take this much time, but we'll revisit it. Okay.
Yes, don't listen.
So, Mr. Montalongo, you're charged with 2 cases. You're charged with assault of a family member. You're also charged with terroristic threat. Both of those, you're facing up to a year in jail and or a $4,000 fine. I'm going to tell you now, you take off on me again, I'm going to make your bond so high you'll have hair falling out. Do you understand? As it stands now, your case is 1,289 days old on one. The other one is around another 2 years old as well. I'm assuming probable cause has been found already.
I would like to take up probable cause, Your Honor, on the terroristic threat one, if we can.
Okay.
Okay, go for it.
Yes, Judge. On February 28th, 2023, the officer responded to a terroristic threat and the complainant stated she is the sister of the defendant and that prior to the day of the call, the defendant had been sending her threatening messages to her phone. The defendant sent a text saying, I hope you take a punch to the fucking face. I'm gonna break your fucking face with my fist, bitch. I want to hear your bones break. The complainant stated the defendant has been verbally abusing her and has a history of assaulting their father.
Your Honor, I believe the key element they're missing in this probable cause for the terroristic threat is the imminency. There's nothing showing that this is imminent, it's about to happen, or is going to happen, or some future event.
I mean, I'm going to.
I'm going to, it can be very vague, Your Honor. We don't know how long that's going to be. If it's like, hey, I'm coming over right now, or if he said that in person. I think the case law is pretty clear on the imminency on that. For example, like.
You're telling me there's case law that says I'm going to is not sufficient?
I have to look at the specific words of I'm going to, but it references a future event. So if it's in reference to a future event, it's not imminent. Therefore, it doesn't meet the requirement.
State response?
So what we have is that they had an argument the previous night, and that the morning of the incident, that's when he sent the text saying, "I'm gonna break your face with my fist." So that would go towards, it doesn't really address the imminent issue, but it does address a future threat.
Montalongo.
Your Honor, I would agree with where you were going, I'm going to, and just the overall tone of the
Mhm.
message is implying imminent and will put a reasonable person in fear.
I think so as well. Mr. Montalongo, I'm going to find that there's probable cause to go forward with your case. I'm now issuing a magistrate's order for emergency protection that identifies the complaining witness in this case as a protected individual. You cannot communicate with this person in any manner. Phone calls, text messages, any way. You're not to threaten, harass, use another person to communicate a threat or harassing behavior. You cannot go within 200 feet of where she lives or where she works. Do you understand? If I find that you violate this court order, I'm just going to put you in jail. Got to understand, I'm going to protect my public at all costs. I don't care who you are, what color, whatever. Do you understand? Now, I'm not waiving his appearance because the cases are super old. We got to figure out where we're going. So I'm going to give you guys one setting to figure out where we're going to go. Is discovery complete on both of these cases?
It appears that the RIP is missing on the terroristic threat, and on the assault, it's complete.
So, okay, so I'm going to give you 30 days. You must be back at that time to figure out what we're going to do. You must either accept a